Well, Peyton, Steven Wiggins was transported from the River Bend Maximum Security Institution in Nashville to the Dickson County Courthouse in Charlotte for today's hearing. Wiggins was sentenced to death for the May 2018 shooting death of Sergeant Daniel Baker of the Dickson County Sheriff's Office. Wiggins previously claimed he did not want to pursue any appeals, but changed his mind.
Hey there, welcome to the Courtroom Files. A quick thank you to ABC2 in Nashville for helping us with our intro there. As you can tell from the intro, this is a hearing in Judge Wolfe's court about a man seeking a new trial. This gentleman was actually convicted back in 2021 in Judge Wolfe's court for first-degree murder of a police officer. He is on death row and is seeking to have his case retried. Now, we present this because this isn't something that you see all the time, not in real life. We see these kind of arguments in TV shows and movies, but it's not often that we get live footage of an entire hearing like this. So it definitely has a unique and educational factor for those reasons. So give it a look. Let us know what you think in the comments about this whole situation. In the pinned comment, we will also include a link from the Tennessean of an article that kind of explains a little bit about the background and his seeking a new trial. So you can give that a look as well. Please put a thumbs up on the video if you enjoy it. That helps other people find it. Consider subscribing to the channel if you have not already. And let's go ahead and roll the game film.
All right, it's a motion for new trial. I'm ready to hear you. I have read through your motion, so I'm familiar with your grounds, and I'll allow you to address whatever you feel like you need to. So.
Thank you, Your Honor. Robert Kurtz on behalf of Mr. Wiggins. Your Honor, as the court is aware, we have briefed fairly extensively this motion for new trial, and of course the state has responded with an extensive response, and many of the issues that we will address today have been litigated fairly heavily at trial and in advance of trial. Mr. Evans and I have divided this up to argue in terms of the guilt phase and the sentencing phase of the trial. I will highlight a few issues that are raised in the guilt phase of the trial. First, Your Honor, if I may, we raised in issue number 2 the introduction of a number of photographs of the decedent's body. If I may approach.
You might. Yeah. You can hand it to the bailiff. He's got longer arms than you do. So.
Your Honor, rather than making a broad objection, we have highlighted the specific photographs that were introduced into evidence that we do object to. This was the subject of a pretrial hearing as well as objections at trial, so I won't brief this anymore other than to say that the introduction of the photographs identified in Exhibit 1 to this hearing were less probative than the danger of unfair prejudice. We do believe that they prejudiced Mr. Wiggins and that they warrant a new trial. Other than that, I will rely on the briefing for that matter. The second issue I would like to talk about is the 404B.
Let me have this marked as an exhibit for this hearing. Go ahead.
The 404B evidence that was introduced through the state's witness, Brian Hundal. Your Honor, you may recall that Mr. Hundal testified to a conversation that he had with Mr. Wiggins, where Mr. Wiggins made statements alleged by Mr. Hundal that were later used against him at trial, specifically in reference to law enforcement. If anybody tries to arrest me, I'll smoke their ass. Mr. Hundal's testimony was very vague. He said that he met Mr. Wiggins a few times between February, March, and April of 2018, and in his testimony he was not able to identify a specific time frame of when that statement was made. A pretrial motion was filed, a hearing was held outside the presence of the jury on December 16, 2019, and an order went down on January 15 of 2020. The court did hold a hearing outside the presence of the jury, but the court respectfully did not make a determination on the record as to the material issue that testimony went to. In fact, the court put down a written order on January 15, but it did not specify what the material issue was. And what adds to the confusion there is the jury instruction that the court gave as to that issue. On page 28 of the jury charge that the court read, it said that if the jury finds that this evidence was for the complete story of the crime, it may be considered where the prior crime and the present alleged crime are logically related or connected or are part of the same transaction, so that the proof of the other tends or is necessary to prove the one charged or is necessary for a complete account thereof. It then goes on, the jury charge goes on to say that it may be considered for motive. And I would submit to the court that that was error, that is an incorrect statement of the law, that it actually—
Let me ask you a question. I'm sorry for interrupting you, but I know you were not trial counsel. Was there an objection? Maybe we had a pre-trial, we had a jury conference where they were given, the counsel for the defendant were given copies along with the state of the jury's proposed instruction. And I just wondered, was there any objection made to that particular language by the defense?
It doesn't appear in the record that there was an objection to that language.
I don't recall there being one.
I believe that's
Obviously,
correct.
I would have addressed it on the record had there been.
I believe that's correct, but I think the court's failure to state on the record what the material issue was is the error here that we're looking to address. And I think that that part of the jury instruction then reinforced, because it was making it would go towards showing, or in the jury's mind, convincing them that this was a premeditated plan by Mr. Wiggins as far back as March, April, or February, prior to the incident in May of 2018. And so we think that the error, in addition to the jury instruction, amounts to reversible error, and we would ask the court to grant a new trial on that ground as well. If the court doesn't have any other questions on that issue, I'll move on to the last issue that I'd like to highlight, and that is the statements of the state's counsel in closing argument, Your Honor. There were two sections that we have highlighted in the brief, and that is the closing both in the penalty phase and in the guilt phase and in the penalty phase. In the guilt phase of the trial, you may recall that the state's theory, their catch, was that this was a thin line of justice, a thin blue line of law enforcement. The thin blue line was burned that day. The thin line of justice does not need to be burned by the acting of the defendant. Now, I think that crosses a line, and I think on a number of levels. First, it is about deterrence, and I think it is saying that that Mr. Wiggins, that the only way you can deter this conduct is to put him to death. I would also say that I think it is appealing to the passions of the jurors, talking about the thin blue line, which is just clearly a reference to law enforcement. And I think equating the jurors' mission to law enforcement was prejudicial in this instance.
And again, excuse me for interrupting you, but, and I know you weren't the trial counsel, but was there an objection made contemporaneously with that argument at the trial?
There was not an objection made contemporaneously, Your Honor, and the error that we are suggesting in this pleading is under State v. Watkins, where we suggest respectfully that the court has a duty to act proactively in those instances and to correct any prejudicial remarks made by counsel. In terms of the penalty phase, Your Honor, we would also object to the comments of the state's counsel when it was commenting on the mitigation that was presented in the penalty phase by the defense. And specifically in volume 7 of the trial transcript, page 967, counsel is referencing Mr. Wiggins' interaction with some of the expert witnesses that were presented. And counsel says, quote, "Who is he lying to? Why is he lying? Mitigating. He's mitigating." Now that is a direct attack on the mitigation that was provided by the defendants, and that is not permitted. They are talking about the mitigation evidence. They're talking about why it should not be considered and why it is not valid for the jurors to consider. And we believe under Hitchcock v. Duggar, Eddings versus Oklahoma, and Lockett v. Ohio, that crosses the line into impermissible commentary on the mitigation proof, and that it also warrants a new trial. Now, as the other issues, Mr. Evans will raise the issues that address more in the penalty phase, but if there are any other issues in the guilt phase of the trial, I'm happy to address those for the court.
I don't think so. I've read through your motion, so I'm familiar with all the argument. Mr. Evans is going to address the other issues.
Thank you, Your Honor. So as to the penalty phase of the trial, obviously, as Mr. Kurtz said, we're relying primarily on the briefing in this case for our arguments for the court's review. But I just want to highlight two areas from the penalty phase of this trial that we believe warrant the court to vacate the death sentence in this instance and grant a new sentencing hearing. One of which is this. We believe the court erred by limiting the mitigation proof in this case, specifically with the defendant's attempt to put on proof as to what I will call execution impact. If Your Honor recalls, from the trial, the defense put on several mitigation witnesses, Pete Schaefer, Julie Kreisman, Scott Wiggins, and Juanita Wiggins. At that point in time, defense counsel attempted to elicit proof from those witnesses as to how Mr. Wiggins, if executed, that would affect them. And the court, the state objected, the court sustained that objection and limited that testimony. We then put on an offer of proof for each one of those witnesses. We believe that the court unnecessarily and erroneously limited that testimony in this instance, specifically based on what we know from case law, such as Cawthorn, and the very broad latitude from Cawthorn in in Tennessee state courts, as well as Skipper, the U.S. Supreme Court, that defendants are given when they are facing the death penalty to put on any mitigating evidence. Even the statute, the Tennessee state statute, talks about any mitigating evidence. And this would have been mitigating. If you look at Cawthorn, any aspect of a defendant's character or record in any of the circumstances of the offense the defendant proffers as a basis for a sentence less than death. It goes on to say it includes background and character evidence in the form of expressions of love and support from the defendant's family. In this instance, Judge, that would have been meaningful for the jury to hear, to be able to hear that he had individuals in his life that loved him so much that they would have been impacted. And I understand the court in its ruling on this essentially tried to compare this to the victim impact and tried to say, well, if I have to limit the victim impact testimony, I likewise, why would I allow this? If I have to overly limit victim impact, why would I have to limit this?
My recollection is that I did not allow anyone for the state or anyone for the defense to say what they thought the jury should do to give their opinion about what they thought the jury should do regarding the imposition of the death penalty.
And that's absolutely correct. That was a portion that I think one of the witnesses essentially spoke about, but the further limitation on the evidence was their ability to speak on how, if he was executed, that would impact them. So your Honor's correct. There was an objection made as to, I think, the first witness that we called.
We had an out-of-jury hearing regarding Mrs. Baker's victim impact statement, in which I was compelled to rule that there were certain portions of her statement that could not be introduced to the jury, and I limited what she was able to say to the jury in an effort to try to avoid any sort of error, and that we also then addressed the issue about the defense witnesses and the impact that they, or what they wanted to do about, what they were asking the jury to do about that. That's my recollection. Obviously, I'll have to go back and reread the transcripts to be able to address that.
Yes, Your Honor. And I'll say there was two distinct issues that were raised. I think Pete Schaefer was the initial defense witness that really unsolicited made a statement about the death penalty, which caused the court to stop when we had a jury out. That being a separate issue, we also addressed the issue of execution impact, where the court limited our ability to ask those witnesses about how Mr. Wiggins being executed would impact them. And we believe that that was a unconstitutional infringement on his right to present mitigating evidence, and surely something based on Skipper that would have been within the universe of any and all relevant mitigating evidence that could cause any single juror or all jurors to vote for something less than a death sentence. And so for those reasons, we would ask the court to vacate the death sentence in this case. The second issue that I want to highlight for the court that we raised in our briefing was that we believe the court erred by allowing improper rebuttal proof to be put on by the state. Specifically, and as Your Honor may recall, we put on witnesses in our case that talked about Mr. Wiggins not having a bad institutional record. He had followed the rules in the jail. He'd been a model detainee at the jail. The state put on a personnel from the jail in rebuttal to say that he in fact had broken a rule, which was he had gotten tattoos while he was in the jail. The state had noticed the defense at that time that they intended to actually put the tattoos and pictures of the tattoos into evidence. And of course, as Your Honor may recall, the defense objected. We had a hearing on the admissibility of these tattoos, their pictures and what they actually said being put into evidence. And the court overruled the objection and allowed these tattoos to be put in, one of which said the words, "Death row, ain't got no time for that, hellbound, crush your enemies, and show no mercy." Your Honor, we believe that that was reversible error in this instance and not probative in any sense of the word. The fact that the state had actually put on a witness to say he had gotten tattoos and violated the rule was sufficient to rebut any indication that he had followed the rules. There was absolutely nothing probative about putting in the substance of those tattoos. The only purpose for putting in those tattoos at the rebuttal phase of the sentencing hearing was to inflame the jury, prejudice the jury, to show specific references to death row, hellbound, show no mercy, which the state then utilized as an argument in favor of the death penalty. And the inclusion of those tattoos in and of themselves, we believe was reversible error that warrants this court to vacate the death sentence in this case and grant him a new sentencing hearing.
All right.
If there's no other questions for the court, we'd rely on our briefs for the remaining issues.
All right. So you're submitting everything else, all the other arguments you're submitting on the briefs, right?
Yes, Your Honor.
Okay. State ready to respond?
Good morning, Your Honor.
Good morning.
So I will directly respond to Mr. Kurtz and Mr. Evans' arguments today, and the state will rely on the rest of them on our brief that we've submitted. I believe that's a 50-some page response to them. First issue brought up by defense counsel was issue number 2 of the photographs that were submitted at trial. As Your Honor has previously stated, we did have extensive hearings on which photos the state would like to rely on. All of those photos were litigated. I know that the defense counsel maintained their objections to those photographs. However, Your Honor, we believe did rule extensively and correctly on those photos. Each and every one of those photos we submitted proof on about what issue it went to at trial, what evidence it was going to show, and Your Honor limited the state's use of some of those photos. So we believe, again, we'll rely on our brief and all the possible hearings that we've had on this, that they were admitted legally. Issue number 3 that was brought up by defense was the 404B issue with Mr. Brian Hudnall with a statement of "all smoke their ass." Again, this was heavily litigated. There was, as Your Honor said, no objection made at trial when this came in. We do believe that this is probative of the defendant's mindset at the time. Mr. Hudnall was clear about it was earlier in the month that Sergeant Daniel Baker was murdered. This went to show the defendant's mindset. We also knew at this time that he was on the run from community corrections violations, and he had an interest in evading law enforcement. We believe that that was properly admitted and litigated at trial. Issue number 3 that was brought up, the closing argument, where the defense has an issue with the thin blue line being brought up. Again, as Your Honor noted, there was no objection at trial. This is absolutely permissible. It is powerful and impactful, but that's what closing argument is supposed to be. There was overwhelming proof of guilt in this trial, and the victim in this case, Sergeant Daniel Baker, was in fact a member of law enforcement. There was nothing impermissible about this argument, and we should not be granted a new trial for that. Moving on to the penalty phase argument, again, the statements made about the defendant lying and who is he mitigating, that was brought up in proof. The defendant gave multiple examinations, undertook multiple examinations, and the results of those were placed in front of the jury and the court, and they were incongruent. I mean, it was obvious that he's making multiple statements and in order here to more than likely mitigate. We believe that this was absolutely not improper to comment on. It was proof that was before the court. Moving on to the penalty phase, the issue there that was brought up was the mitigation about execution impact. And Your Honor, we believe that this is much more like the State v. Hester, 324 Southwest 3D, pages 59 to 60, Tennessee Supreme Court in 2010. And in there, specifically, the court was dealing with another capital case, and the court stated, Mr. Hester does not cite a single authority supporting his argument that a court must admit evidence that a surviving victim opposed the death penalty and therefore does not believe that the defendant should be executed for the murder of the deceased victim. Nor does our review of the case law suggest that such testimony is required to be admitted. To the contrary, such testimony is considered to be irrelevant. Wayne A. Logan, opining on death, witness sentencing recommendations in capital trials, 41 BC Law Review, 517, 534, 2000. And courts have consistently held that such testimony is inadmissible. Accordingly, we decline to find that the trial court abused its discretion by declining to permit Ms. Hester to testify about her philosophical opposition to the death penalty or her opinion that Mr. Hester should not receive the death penalty. We believe that the defense is attempting to sort of back a door around this by talking about execution impact. Arguably, there's impact to everybody in the death of somebody, specifically in law enforcement. And here, the community has been affected. We didn't have statements about the community's impact about losing one of their law enforcement leaders. While it is tragic that everyone is affected by this, these were actions taken by the defendant. The defendant caused this and the natural consequences of that. However, the defense cannot parade people through the court system attempting to lean on the emotions of the jury about how executing or holding Mr. Wiggins responsible for what he did would impact them. Again, much like Your Honor had limited the victim's impact testimony, we believe that this was also properly limited. And finally, on the last issue of the rebuttal proof for the jail tattoo that was admitted as evidence, again, we had extensive litigation on this, and Your Honor gave a very lengthy opinion in the trial transcript, punishment phase, volume 6, pages 852 to 854. And, it does directly go to statements made by the defendant and what he was trying to offer and mitigate the violent nature of his character. This was absolutely properly admitted, and those reasons we would submit the rest of this on brief, and we would request that this honorable court uphold the conviction and the death sentence for Mr. Wiggins.
Does the defendant have rebuttal argument?
Judge, just briefly, I want to make sure that this issue of execution impact isn't confused. And the state's argument, that we're trying to backdoor this execution impact to get around allowing people to discuss their views on the death penalty. I believe the cases are Hester and Odom, if I'm not mistaken, that the court relied upon at trial about someone's ability to say their feeling on the death penalty from the witness stand. That's not the issue. That's not the issue. The issue that we are addressing in this motion is execution impact. Look, the community coming in and saying their loss of law enforcement is not mitigating, right? The law allows for mitigation. State law, and then the federal constitution, and the cases that describe it, like we talked about, including Skipper, which give broad latitude in mitigation proof, and allowing someone to come in, a family member of this individual, to show their love and support. And part of that, which is directly from Courtroom, is them saying, yes, it would devastate me if they weren't there for me to call them, for me to have them in their life, even from serving a life sentence. They have meaning in my life. That's meaningful. That's allowed. That is permissible, and it should have been permissible in this case. As to the rebuttal proof, to suggest that those tattoos were somehow not, we didn't hear one word from the state about the prejudicial nature of those. And I understand the court gave a very lengthy explanation for its ruling at trial. But the context by which it was initially argued for the state to put in that evidence was specifically about whether he had gotten tattoos in jail. And they put someone in to say he got tattoos, and then wanted to go the step forward because of the salacious nature of what those tattoos said. And put us in a position where we can't rebut it. What can we say? People get tattoos all the time. They don't necessarily, doesn't mean that they, if someone says no mercy on their, tattooed on them somewhere, doesn't mean that they are going to go, act on that. People get tattoos that say other things, but we are in the position then of what are we supposed to do? How are we supposed to explain those tattoos with a defendant who's facing the death penalty and it has a Fifth Amendment right? So we were completely unable to rebut anything of the suggestion. And it was outlandishly prejudicial. It directly spoke about death row. It directly spoke about other things that were all salacious in nature. They were all, the only purpose of which, was to inflame the jury and allow the state another avenue to argue about no mercy in a case where a jury is deciding whether or not to show mercy. That's a problem, we believe, and that's why we've argued that. So, Judge, for those reasons, we'd ask again for the court to vacate the death sentence in this case. We appreciate the court's time.
I want to give both sides the opportunity to make sure that everything is addressed. Is there anything else that the state wants to address? All right, this is a case that obviously has stayed with me for all these years, and I'm familiar and recall much, if not all, of the trial and all of the issues that have been raised. In almost every instance, I have, in my opinion, we had pretrial conferences, pretrial hearings, and orders were put down, rulings were made prior to the imposition of, or prior to the actual admission of any of that evidence. And so I am, having reviewed this file and having reviewed the motion, I'm of the opinion at this point that I do not believe that there was any reversible error made, but I'm going to go through and deal with each of those in a written order so that I can make sure, and obviously the citations that Mr. Evans has made has regarding the admission of certain evidence or exclusion of certain evidence at the punishment phase, I'll address that as well. But I think my recollection is that in every instance we had extensive hearings and a detailed order was put down regarding that. And so I expect that I will stand on those orders and all of the rulings that I've made, but I want to make sure that I've given adequate attention to all of the issues and all of the arguments that are made, and I will address those in a written form. So thank you. And I will hopefully have that sometime in the very near future. Is there anything else then before we recess this case?
No, Your Honor.
And I do recall one thing. Was there an agreed order on the photographs that was entered into at trial that limited some of those and admitted some others? It seems like I recall that having been done. Just turn that microphone on if you want to. Yeah, I just recall that there was an agreed order that limited certain photographs and admitted by agreement certain other photographs, and that's why I thought that was the case. But okay, there was an announcement made on the record, and we have, Ms. Jones, I have we'll make you a copy of those exhibit numbers of the photographs that they've raised as an issue. So my assistant capital case attorney, Ms. Jones, is obviously assisting me in dealing with this motion since she sat through the entire trial with me. All right, if there's nothing else, then we'll ask that Mr. Wiggins return to holding, and we'll move on to the next case on the docket. So.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.